Hello, scholars. I hope everyone's having a lovely day. And today we are going to be going into and discussing the Establishment Clause, which is one of the other religion rights. It's the other religion right that's mentioned in the First Amendment. Again, there's the Free Exercise Clause and the Establishment Clause. So let's go into that. Let me pull up the presentation again. This is a presentation that should be available. It should be on my lecture notes link on the Synergy page. So again, freedom of religion, there are two main religious liberties, the Free Exercise Clause, which we discussed in the previous lecture, and the Establishment Clause. So let's contextualize the Establishment Clause, because often we look at it from a very a modern perspective, sort of not understanding what the framers were trying to do with it. So the first thing to understand is that the founders and the framers were reflective of the European history, that religion was often the cause of bloodshed. And certainly, if you know anything about the history of Europe, there was ample historical precedent. Certainly, just the history of England, where if the government, for instance, was Protestant, it would murder and persecute the Catholics, or if the government was Catholic, it would murder and persecute the Protestants. So the founders and framers sort of recognized that and realized that they needed to have a position on religion. Most governments out there do actually have official religions, whether it's Italy, where it's the Catholic Church, whether it's England, whether it's the Anglican Church. Many countries, most countries, have official religions. The United States is unusual in that we not only don't have an official religion, but that secondarily, the other thing that we have is we have the Free Exercise Clause, which allows the individual to pursue their own religious beliefs. So, some countries have free exercise clauses, some countries don't have an official religion. It's pretty unusual to have both. Both you're allowed to pursue your own religion, and as long as you don't again break any laws, as well as the government cannot select an official religion to prefer and promote. So that's not to say that there cannot be a governmental acknowledgement of religion. Presidents, when they are sworn in, they put their hand on a Bible. They say, "So help me God." There is references to money, in God we trust. So there is a variety of religious references that are out there, and those are not seen as prohibited under the Establishment Clauses. Um, Now, one of the reasons for the Establishment Clause is also not only philosophical and historical, but also very concrete. The United States was already religiously diverse by the time sort of we came about as the United States. And so the United States would have had a very hard time choosing an official religion. Some states did. I think 9 out of 13 states actually had official religions, but at the federal level, it would have been very difficult to figure out, are we going to be Congregationalist? Are we going to be Anglican? Are we going to be, what are we going to be? That would have been actually very, very hard to figure out and probably would have led to violence. So it's the reason why the federal government, very officially will not select an official religion as sort of the right one. So when we look at the Establishment Clause, there's generally two schools of thought. Non-preferentialism, where the government will not support a particular denomination, but will and can support general Judeo-Christian beliefs. So, a general prayer, for example, before a legislative session or before a city council meeting. That sort of thing is often allowed. Now, separationism, and there's a phrase, separation of church and states, not actually in the Constitution. It comes from a letter that Thomas Jefferson had written to the Danbury Baptist Association. And under separationism, the idea is that there must be a wall between the government and religion. Now, I'm going to sort of broadly generalize here, and when you guys go to law school, you can be horrified by my broad generalization. Generally speaking, when we talk about the schools, we tend to have more of a wall of separation. Whereas when we talk about outside of the schools, we tend to be less 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 convinced we need this sort of rigid separation. So schools are a little bit different, and public schools certainly, we have to be very careful and very thoughtful in making sure that it doesn't appear that the school is endorsing a particular religious denomination or sect, um, while at the same time protecting the free exercise rights of students who are allowed to have their own religious beliefs and their own religious practices. So let's talk about the outside of school. What do we generally see? You probably don't know this, but most property owned by religious groups is actually tax exempt. Most public officials take an oath of office under the name of God, saying God we trust. Sessions of both Congress, state legislatures, many city councils start with a prayer. The nation's anthem, say, obviously as a reference to the divine, as do our coins and currency. The court has even ruled that it is constitutional for an enormous cross to be placed on public land, federal land, in honor of World War I soldiers. So, again, outside of the schools, acceptance or affirmation of general Judeo-Christian values is generally allowed. Inside the schools gets a little trickier. Now, one of the first cases that is going to look at the schools is this Efferson versus Board of Education. And this was essentially a system where there was a bus system. And in New Jersey, in this bus system, students could take the bus to get to school. Some parents who were low income, that was sort of expensive. So the school district reimbursed parents to take the bus to get to school. So the parents didn't have to pay for the bus. The question was, could you reimburse parents who were having their kids go to a private religious school? And the answer was yes. That because it was the students who were deciding, or the students and their parents who were deciding to go to a private religious school. Because the government wasn't explicitly giving money to the school, that was fine. Now, in another area, so the support of and there's been subsequent decisions involving vouchers and private schools and all sorts of stuff. There's even right now sort of an argument about Betsy DeVos, the Secretary of Education. But the issue there again is, so long as it is sort of the choice of the parents where the kid is going to school, some support for the parents is allowed. Now the other is release time, and many schools, including our own, have a policy that students are allowed to be released during the school day to get religious instruction. There are two main cases for this. In McCollum versus Board of Education, the Supreme Court ruled that it was impermissible to have religious leaders come to the schools during class time and deliver religious instruction basically during the school day, during the actual class time. But in Zorach v. Clausen a few years later, they said yes, but if the students leave the campus and get religious instruction off campus, that's fine. So again, the sort of the balance here is the court has held that you can't or you shouldn't have religious instruction in the classroom by religious leaders during the school day, whereas you can release students to go off campus and receive religious instruction outside of the campus. So that's sort of, so we're getting some early rulings in the 1940s, 1950s. We're getting rulings trying to figure out where are the boundaries. Okay, where do the boundaries exist between these two areas of law, or these two areas of school and religion? So lower courts are trying to figure this out. Schools are trying to figure this out, and to help this, the Supreme Court came up with something called the Lemon Test. from a case called Lemon v. Kurtzman. And the question in Lemon v. Kurtzman is, can public school money be used to pay for secular instruction? So in other words, could you pay private religious teachers to teach math? So long as the math instruction was non-religious, we call secular. And could that money be used? It's funny. I got here yes, and the answer is no. They can't. So under Lemon, the money could not be used. So I'm not sure why that says yes. Now the question or the standard that comes out of Lemon test is really important. Each time there's a question, right? Each time there is a question that the schools have got to figure out, is this a violation of sort of the Establishment Clause? You ask three questions. First, what's the purpose? What's the purpose of the policy? So if you are providing, say, textbooks, let's say the public school has these extra textbooks, these extra math textbooks, could they give them to the parochial schools or religious schools? Well, the question you would ask is, well, what's the purpose of providing the books? Is it to promote the religion, or is it so these kids have good math instruction? Right. So that's the idea is if the purpose of the aid is secular, then you're good. Next is its primary effect neither advance nor inhibit religion? So are you, in whatever support you're doing, are you not advancing the religion or hurting a religion? Okay, that, again, seems like a fairly easy standard in terms of what you're doing. And lastly is excessive entanglement. So like I'll give you an example of an excessive entanglement. Back in the oldie days, there was an issue where public schools were providing film projectors to private schools. And the question was, is that legal, right? Can a public school provide a film projector to a private religious school, knowing the private religious school will use the film projector to play, probably religious movies? So the issue actually came down to not what was the purpose of the aid, not its primary effect. It came down to excessive entanglement, because the problem was these private religious schools often didn't have the ability to repair these film projectors, these movie projectors. And so the school district had said, well, we'll just have our tech people come in and repair them for you. And that's where the court sort of said, eesh, no, that's a problem, because what you're doing is then you've got this sort of permanent relationship between this religious school and this public school. So that was part of the problem. So that's the Lemon test. Three questions. What's the purpose? Okay. Does primary effect? Does it lead to excessive entanglement? Some of you are familiar that our English department actually has a unit on, say, sort of the Bible as literature. And sometimes it comes up, well, is that a violation of the Establishment Clause? So let's use the Lemon test to sort of look at that. So why does the English department do the Bible as literature? Well, the reason that they do it is because there's lots, if you look at Western literature, there's lots and lots and lots of religious references. And if students don't know those religious references, they're going to miss the meaning of what these authors are trying to say. And so that's why the English department began to teach, some biblical material, because that way it provided context for many of the analogies and metaphors that you see in Western literature. So the question is, does the English department have a secular purpose? Well, yeah, they're attempting to contextualize this literature. Does its primary effect advance or inhibit a religion? Well, the point of this instruction was not to proselytize. It was not to promote the religion. It was simply to learn these references. Does it lead to an excessive entanglement? Is like a permanent relationship between a church and the school? And the answer, of course, is no. We just buy some Bibles, so that's not there. There's no real entanglement at all between a religious institution and the public school. So looking at the Lemon test, we would sort of conclude that the school was fine. in what it was doing. So we've got so look at some subsequent cases to give us an idea, sort of how does lemon or derivations of lemon, how is it applied? Well, in 1985, there's an interesting case called Wallace v. Jaffrey. In Wallace v. Jaffrey, the law was passed by a state legislature allowing for a moment of silence. That in and of itself may have been all right, but the problem is that in the earlier versions of the law, the law was called basically a moment of silence so students can pray. And obviously, prayer is not secular. So in Wallace v. Jaffrey, the moment of silence law was struck because it did not have a secular purpose. In 1992, you had this case called Levy-Weissman, and this was a question of can local clergy or religious leaders, can they deliver basically invocations and prayers at public high school graduations? And the answer was no, right? And part of it was there was no secular purpose, right? What was the secular purpose in having an invocation or prayer? In another case, Santa Fe Independent School District versus Doe, the question was, could you have a student-led prayer before a football game? And the answer again here was no, that there was no secular purpose in allowing that prayer to be given, and so it was struck. So that's basically when you look at the Lemon Test and sort of how the Lemon Test has evolved, these are some of the rulings that we have, and one of the big ones is that the court has, I think, been real clear on is you just can't have prayer in school. That teachers, at least teachers, cannot lead prayer in schools. Can students privately pray? Sure, that's a free exercise clause. But could teachers lead a prayer? Could a coach lead a prayer? No. So again, as we talked about, this is sort of what the slide says. Teachers cannot lead prayers. Students, because of free exercise, are allowed. Now, this sometimes brings an interesting question about evolution. In some conservative areas of the country, there have been attempts to teach evolution side by side with creationism, sort of a biblical description of the beginning of the world. And the question is, can you do that? Can you teach creationism alongside evolution as a scientific doctrine? And basically, the court has said no, that creationism is a religious doctrine. And there have been sort of iterations where some districts have tried to say, okay, we're not going to teach creationism, we're going to teach something called creation science, or we're going to teach something called intelligent design, sort of iterations. The court has held that these are basically iterations of creationism, where they're trying to figure out ways to still get creationism or some element of creationism taught in the schools. And the courts have said, no, you can't do that. Now, again, if you were going to do, say, an anthropology class, you were going to say, all right, we're going to talk about different anthropological explanations for the beginning of the world. That would be fine, right? If you had a variety of different religious teachings and how they explain the beginning of the world, that would be fine. But you couldn't do it, and the court has ruled you can't really do it as basically a scientific explanation or as sort of the only explanation for why the world is the world. Seasonal displays. Sometimes this comes up, obviously during the Christmas holiday season. Can this occur? Can it happen in the schools? Can it happen outside? Now, obviously, private property, you can do whatever you want. So if you want to put up a nativity scene in your front yard on your private property, hey, more power to you. You can do that. It's your private property. In Lake Oswego, there was kerfuffle every once in a while that Safeway has a Christmas tree in front of their store, and can they do that? And legally, the short answer is absolutely. It's private property; they can do what they want. Now, what if it's a city that wants to put up say a nativity scene? Can they do that? And the answer is sort of like context. Everything is context. So if you have a nativity scene and it's got a whole bunch of other holiday displays there, so you got Santa and you know styrofoam candy canes and reindeer and all sorts of other sort of decorations for the holiday season, generally the court has said that's fine. That general commemoration of the holidays is allowed, um, and so long as it's just one of a variety of decor, you're totally fine. Um, if, however, you just have, say, a nativity scene, or I don't know, a Christian cross, or something, a menorah or something, sort of in isolation, um, the court is less enthused by that, because they then feel that it looks like more of a government endorsement of that specific religion, as opposed to a government endorsement of sort of the holiday season. So that's the general rule. General support of a variety of holiday symbols, you're good. A religious symbol in isolation, less acceptable. Lastly, prayer. Remember, I talked about how teachers could definitely not lead prayer in a class, um, but often there are chaplains or religious leaders who will lead state legislatures in prayer, um, city council meetings in prayer, and that's generally considered to be acceptable. Again, these prayers are generally sort of non-denominational, and they are not in the schools where they're young, impressionable children, but rather these are, um, people who generally go to legislative sessions are generally, well, one, legislators, so they're generally older, generally, less prone to being influenced or pressured. And again, the Establishment Clause, when you're talking outside of school, is mostly concerned more with not choosing a particular denomination or sect to support. So that is basically sort of why that prayers would be kind of allowed in maybe a legislative session, but they're not necessarily going to be allowed in the schools. So I hope you've enjoyed our discussion today of the Establishment Clause. Again, it's a pretty complicated area of law, and it's an area of law that there's a lot of evolution. Um, that there's a lot of change in this. The Supreme Court is looking at establishment cases almost once a year. They're looking at a lot at this area of law, and the this area of law may undergo some fairly significant changes in the next couple of years, or not. We'll know, and I will let you know. So have yourselves a lovely, lovely day, and I will